A divorce decree that orders alimony payments from one spouse to the other may also specify that those payments should cease if the recipient spouse begins cohabiting with another adult. But what does it mean for one person to cohabit with another sufficiently to terminate an alimony obligation? That's the question in the matter of Raybeck. Judith and Bruce Raybeck were divorced after 42 years of marriage. Judith received ownership of the party's house in Laconia, New Hampshire. In a separation agreement that was incorporated into the divorce decree, Bruce agreed to pay Judith alimony of $25,000 per year in yearly installments for 10 years. But if Judith cohabited with an unrelated adult male, Bruce's alimony obligation would cease. Roughly 5 years after the divorce, Judith moved out of the Laconia house and rented it to reduce her expenses. She moved into the top floor of a single-family home owned by Paul Sansoucie, whom she'd met via an online dating service. Sansoucie lived on the first floor. Judith didn't pay rent, but she did pay about $300 a month for food and often cooked for Sansoucie. Judith and Sansoucie shared living space on the middle floor of the house. Additionally, Judith and Sansoucie shared rooms while they were traveling together. Judith told her children that she and Sansoucie had discussed marriage but didn't marry due to personal and financial reasons. Once Bruce learned about Judith's new living situation, he stopped paying alimony. Judith sued to enforce the alimony obligation. After a hearing, the trial court concluded that Judith wasn't cohabiting with Sansoucie and ordered Bruce to resume alimony payments. Bruce appealed to the New Hampshire Supreme Court.